Let us pray. Almighty God, who in your wisdom and goodness have appointed the office of leaders and parliaments for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor as your servants whom you've been pleased to call to the performance of important trusts in this republic. Let your blessings descend upon us assembled, and grant that we consider all matters that shall come under deliberation in so just and faithful manner, and as to advance the peace, prosperity, and welfare of our country, and for those whose interests are committed to our church. Amen. Could bring the quorum bell.
We need 50. You mean unless we go out of Narcotics? Na inasemekana wale ambaye si In cases zingine, you know, this one haina limitation of time, itaendelea tu. The only limitation ni 10 minutes. So, leader of majority ameongea kwa hiyo.
So it's only kuchukua na nilipochukua
Hajaongea. So it's only 5 members.
Hata mimi sasa ninakuwa shwari.
We can now commence business.
Order number 1, administration of oath. Order number 2, communication from the chair.
Honourable members, if you could take your seats. Honourable members, further to the communication I made on Thursday, 25th February 2021, regarding the status of returns by the county assemblies to the speakers of the House of Parliament with respect to the draft Constitution of Kenya Amendment Bill 2020, I wish to give the following updates. Honourable members, in my same communication, I did list the 33 county assemblies that had made returns to the speakers of House of Parliament. In addition to that number, we have since received respective certificates and draft bills from the speakers of the following other county assemblies: Wajir, Marsabit, Isiolo, Kiambu, Lamu, Turkana, Samburu, Nandi, and Bomet. At the same time, the speakers of the county assemblies of Kwale and Nyamira have since submitted the copy of the draft bill, which was debated and passed by their county assembly. County assemblies. Honourable members, the certificates received from the county assemblies I have mentioned indicate that they approved the draft Constitution of Kenya Amendment Bill 2020, popularly referred to as the BBI Bill, except the county assembly of Nandi, which rejected the bill. In summary, therefore, as at close of business yesterday, 1st of March 2021, 42 county assemblies and submitted their decisions on the draft bill to the speakers of the House of Parliament. The 5 county assemblies that were yet to submit their decisions on the draft bills as at close of business yesterday, Monday, 1st of March 2021, were Migori, Elgeyo Marakwet, Uasin Gishu, Mandera, and Kilifi. This notwithstanding, honourable members, it will be recalled that the Speaker of the Senate Adai did communicate to our respective houses that the draft Constitution of Kenya Amendment Bill 2020, popularly referred to as the BBI Bill, has met the threshold contemplated under Article 257, Clause 7 of the Constitution, having been approved by a majority of the county assemblies. Honourable members, having said that, there are 2 procedural questions that have been brought to my attention relating to the process of consideration in Parliament of a bill under Article 257 of the Constitution. These 2 issues are: 1, should the bill be republished, and if so, what value will the republication add to the process? And 2, does Standing Order 120 regarding the 14 days maturity period applied to such a bill before its introduction in Parliament? Honourable members, You will recall that during the period of admitting returns from the county assemblies with respect to the Punguza Mizigo initiative, the Speaker of the Senate Adai did observe that our rules of procedure are deficient with respect to fully actualizing the parliamentary process contemplated under Article 257 of the Constitution. With respect to the 14 days maturity period before first reading, the House is aware that the maturity period is a Commonwealth parliamentary practice which is aimed at according the House and indeed the general public of a notification period on the presence of a bill before its formal introduction in the House by way of its first reading. This, however, applies to a bill being introduced in a House for the first time. It does not apply to a bill that has originated from another House. As such, bills originating in the Senate are not subjected to this publication period. However, honourable members, with respect to a bill under Article 257 of the Constitution, such notice period will serve little value. As members will note, Article 257 of the Constitution contemplates expeditious processing of a bill to amend the Constitution by popular initiative. Specifically, Clause 7 of that article, which notes that such a bill shall, in quotes, be introduced in Parliament without undue delay, is, in my view, instructive. To my mind, the urgency implied by the provision seems to be drawn from the lengthy process attached to the consideration of the bill in terms of collection of signatures in support, verification of the same signatures, public participation by the various county assemblies, and ultimately approval by the county assemblies. I am of the considered opinion, therefore, that the House is under an obligation to do everything necessary within its powers to expedite the introduction of the bill for consideration. Honourable members, in our consultations over the processing of the bill in the two houses, the Speaker of the Senate Adai were initially of the view that it should be republished before its introduction with minor changes to reflect the current year, 2021, on its face and to include a footnote indicating its approval by a majority of the county assemblies pursuant to the provisions of Article 257, Clause 7 of the Constitution. Indeed, the clerks of the Houses of Parliament who had been directed to republish the bill had so requested the government printer to expedite the republication of the said bill. But honourable members will note that should the bill be republished with the said footnotes, it completely changes from being the bill which has been approved and considered by the various county assemblies. Indeed, even to have the year 2021 on it would mean it's a different bill. Honourable members, in order to protect the integrity of the bill as proposed by its promoters and presented to the county assemblies as well as the process contemplated under Article 257 of the Constitution, I am now of the opinion that republication of the bill would serve no practical purpose, may lead to unnecessary delays in the introduction and consideration of the bill, and may create confusion as to the operative fashion of the bill. Consequently, the House Business Committee, at its meeting held today, Tuesday, 2nd of March 2021, has resolved that the bill be introduced in the House for first reading on Thursday, 4th of March 2021, in the form that it was presented to the 47 county assemblies by the Independent Electoral and Boundaries Commission. In this regard, honourable members, and pursuant to Article 257 of the Constitution, I do direct as follows. 1, that the draft Constitution of Kenya Amendment Bill 2020, popularly referred to as the BBI Constitutional Amendment Bill, be introduced in the House for its first reading on Thursday, 4th of March 2021. And 2, that the Clerk of the National Assembly urgently obtains sufficient copies of the said bill in the form that it was presented to the 47 county assemblies by the Independent Electoral and Boundaries Commission to enable its introduction into the House as directed. Honourable members, the House is accordingly guided, and I thank you. Thank you. Proceed.
Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Leader of the majority.
Thank you, Honorable Speaker. I beg to lay the following papers on the table of the House today, Tuesday, March the 2nd, 2021, evening sitting. Reports of the Auditor General and financial statements in respect of the following institutions for the year ended 30th of June, 2019, and the certificates therein. 1, Technical and Vocational Education and Training Authority. 2, Anti-Counterfeit Authority. 3, Kenya Industrial Property Institute. 4, the European Widows and Orphans Pension Fund by the National Treasury. And 5, Consolidated Fund Services, Public Debt, the National Treasury. 6, the National Council for Nomadic Education in Kenya, State Department for Early Learning and Basic Education. 7, Kenya National Commission for UNESCO. 8, National Authority for Campaign Against Alcohol and Drug Abuse. 8, Public Trustee of Kenya. 9, Kenya Literature Bureau. 10, Consolidated Fund Services, Pension and Gratuities, the National Treasury. 11, Karatina University. 12, Kisii University. 13, Consolidated Fund Services, Salaries, Allowances, and Miscellaneous Services. 14, Consolidated Fund Services, Subscriptions to International Organizations, the National Treasury. 15, State Department for Crop Development. 16, Rice-Based Market-Oriented Agricultural Promotion Project by the State Department for Crop Development and Agricultural Research. And lastly, the State Department for Early Learning and Basic Education. Thank you, Honorable Speaker.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
None.
Order number 8, motion, inquiry into the optimization of revenue in grain handling services at the port of Mombasa. Question to be put.
Honourable members, I confirm that the House still curates. You have the requisite numbers for me to put the question. Honourable members, just to note that the debate on this motion was concluded on 25th of February 2021. And what remained was for the question to be put, which I hereby do. That this House adopts the report of the Departmental Committee on Finance and National Planning on its inquiry into the optimization of revenue in grain handling services at the port of Mombasa, reigned on the table of the House on Thursday, November 26, 2020. Will as many as that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it. Next.
Order number 9, the County Statutory Instruments Bill, Senate Bill number 21 of 2018. Resumption of debate on second reading.
Was somebody on his feet? The Honorable Mansa, is it? You have a balance of 8 minutes?
Thank you, Mr. Speaker. Mr. Speaker, the County Statutory Instruments Bill it deals with the statutory instruments or delegated legislation from the county, Mr. Speaker, whereby the CSC or the minister of the county, Mr. Speaker, is likely to make some regulations, Mr. Speaker. And this started a long time ago during the time of the counties, and currently is being aligned to the practice at the National Assembly or what's happening at the national government, where cabinet secretaries, Mr. Speaker, are able to make regulations, and they are approved by this House, Mr. Speaker. And the same process we apply here is what is now going to be duplicated in the counties, Mr. Speaker. And this, as I said, have been running even during the time of county councils. The collection of revenue in county councils have regulations, the leases in the county, the county governments, the issues to deal with health, because health is devolved, agriculture, like currently, the way we are dealing with the case of locusts in quite a number of counties. So all this, include even COVID, like COVID regulations were made here. Some will apply from the national down to the counties, and some will be specific to counties and to specific counties. So this has been operating without a law, Mr. Speaker, and there has been a lot of, non-compliance or at times misuse of the regulations made by the counties through their executives. And that's why, Mr. Speaker, we are now supporting this bill. It has been developed from Senate so that the same can be duplicated at the counties, and there could be order. And the same system we use here, Mr. Speaker, so that there is no law which is made from the counties without an approval of the elected members of the county assemblies, made especially by the county assembly itself. It's a way of making sure there is accountability, making sure that there is fairness, and making sure that whatever regulations are made at the county are reasonable and are meant to serve the people, and also follow the law, so that such that, Mr. Speaker, they are constitutional and they are regulated by an act of parliament, so that they cannot go outside it. The same practice, Mr. Speaker, we do public participation before we approve these regulations, to make sure that public participation has taken place. The stakeholders dealing with that particular matter participated. It's one of the tests. It is constitutional. And also making sure that there are records, Mr. Speaker. And where an instrument has been made in the county, it can also be annulled by the assembly there if it has not complied with the law, or in one way or another, it is unconstitutional or illegal. And therefore, this is going to make sure a lot of illegalities which have been committed there in the counties, or some torturous regulations or regulations which were which have not been also approved by the people through public participation, have been in operation in a lot of counties. I believe this law will not be applied retrospectively. The moment it becomes a law, it's going to be practiced immediately thereafter. And most probably, a lot of instruments now, which are operational in the counties, will now be approved properly by the county assemblies, and will be able to serve the people in a better way, Mr. Speaker. And therefore, I believe this is a very good law. We have been doing it here and making sure whatever government regulations are made, and the regulations are pursued to acts of parliament. A lot of scenarios, we do not have really acts of county assemblies, but definitely some of the regulations even originate from a statute of law which already exists, but have to be applied at the counties if the function is devolved, like the health regulations. Some will be specific to a specific county, or there can be an outbreak which is specific to a specific county, and then regulations have to be made. And therefore, when they are made, then they have to be ratified by the assemblies there. So, Mr. Speaker, I believe it is a very good law. It's going to serve the country better. It's going even to cause now a committee of the county assemblies dealing with delegated legislation similar to what we have here. And I believe this is going to improve the service delivery to the people. Mr. Speaker, I beg to support, and I thank you.
Before I go to the next member, I was just wondering, sometimes I wonder whether the entire order paper is uploaded always on the website, even for the evening sittings. If it is, I'm just wondering that the business that we've just concluded, the mover was not in the house. I think chairs of committees are encouraged to be present when their matters are coming up for decision. Next on the order paper, the Honorable Millie Odhiambo.
Thank you, Mr. Speaker. Mr. Speaker, I do support the bill. And in supporting the bill, I want to say that it is timely because the counties have been operating without a regulatory framework in a lot of the issues, which has created confusion. At the national level, thanks to Honorable Amina Abdallah, we have such a law that has guided the way the national government works, especially in the issues of delegated legislation. Mr. Speaker, in my constituency, the lack of such frameworks has affected fishing, especially on fish caging, because sometimes you have the officers operating without a regulatory framework, and sometimes discretion gets to be abused when there is no regulatory framework. So when you have this, at least it will ensure that there is a way that the counties will be able to deal with the fishing sector. Mr. Speaker, the other issue that I've noticed, though, that is of concern, that we now have a regulatory framework for the counties and at the national level, but there are times when you have conflicting roles where you have concurrent mandates with the counties and the national and the counties and the national government. And in such a situation, it actually impacts negatively on the people that the regulations seek to help. Again, I will give an example of the fishing sector, where we've had a back and forth, especially on issues of fish caging, where we don't know which body or who has the mandate of what, who has the mandate of allowing fishermen to do caging, who can stop them and all that. So when you have this law, it will be very, very good. Mr. Speaker, I don't think there's much to say in relation to this bill. It's done well. But I do just wish that we could make certain amendments. I know that members always wonder why I insist on gender when it is already provided constitutionally. But as I was telling Honorable Kaluma last week, only the wearer of the shoe knows. Even though it is provided constitutionally on the issues of gender, in practice, when you don't provide it by law, people just turn a blind eye and they don't actually comply. But when it is in the law and re-emphasized in the law, then there is compliance. And because of that, Mr. Speaker, I would wish that, for instance, on clause 7.1 on regulatory impact assessment would include gender as a condition. And Mr. Speaker, sir, also in clause 22, where the principles to be considered, whether the instrument is good, that would actually consider the effects either directly or in effect on groups such as for women, persons with disability, and marginalized communities. Because if we don't do that, sometimes even a good instrument can have a negative impact. Like if you do a regulatory instrument that focuses, say, on doing work, something on Saturday, and you come to my constituency, you will not get the women, because most women are the ones who attend church. Men are averse to attending church. So you probably will get the men. So you must actually always look at those kind of issues. And Mr. Speaker, that again appears in clause 22, 2D. Mr. Speaker, I think those are the only concerns I have. But also, sorry, I was also just concerned that I hope the mover can speak to this when he's responding in 23, in 20 subclause 3, where we are talking about retrospectivity of the instrument, and I do not understand why we should, in certain instances, apply. So maybe if they can, the mover can just clarify in respect to that. Otherwise, I support. Thank you, Mr. Speaker.
I think it's a very interesting observation about this gender issue, because as you rightly pointed out, Honorable Millie, it is there, but you like emphasizing it, which is okay. I only think that if you read something that I think many of us may have read in the print media of late, to see what's happening with one of the first world countries in Japan, that the ruling party, the LDP, has for the first time in history invited 3 women to go and listen to these men discussing how to lead. And you know, just the other day, the gentleman who was the director of the Olympic Organizing Committee was forced to step aside because of the remarks he made that he generally doesn't like meetings with women because they make too much noise. I'm sure you read about it, Millie. I think we need to have some meetings with some of these people so that they can hear some of these concerns and how it is practiced here. Honorable Sankok.
Thank you very much, Honorable Speaker, for giving me this opportunity to also inject my voice, and especially not coming from the angle of gender, but also coming from the angle of persons with disabilities. Honorable Speaker, but before I go to specific clauses, Honorable Speaker, you know the Constitution 2010 came with devolution, and we really devolved a lot of resources, but we did not care devolving powers, Honorable Speaker, and also to manage those resources, and also the powers to make certain regulations. So it was an amorphous kind of devolution in which, Honorable Speaker, some roadside declaration were being made touching on very important issues and very important sectors like the health sector and water and other very important key devolved function, Honorable Speaker. Honorable Speaker, this county statutory instrument bill, Senate Bill number 21 of 2018, have come at a very right time, Honorable Speaker. It should have come like yesterday, but now that it is here with us.
There's a point of order.
Mr. Speaker, we have COVID-19 with us, and our colleagues there, one is running away already. So, exactly. Even up there, I think people are not really sensitive to the times we are, Mr. Speaker, in terms of sitting arrangement. Thank you.
Social distancing. Honour members, you are encouraged to social distance even as you remain masked. Proceed, Honourable Sankok.
Thank you very much. It's only unfortunate that Honourable Ngedi is out of order herself. We don't have friends here, we don't have people here, we have honourable members of the August House. Honourable Speaker, as I was saying before I was rudely interrupted, that Honourable Speaker, we really need Honourable Speaker to devolve and powers so that this regulation and these statutory instruments are made in the right channel and to be specific to the specific need of certain regions, Honourable Speaker. Honourable Speaker, making laws in this House have been quite difficult because of trying to balance regions, because the law that does well in my region, in Masailand, may not be the same law that will do well in Moroni, where Honourable Koyo represents, and may be traditionally in conflict with people from the North, Honourable Speaker. But Honourable Speaker, when we have these laws being made from the County Assembly, Honourable Speaker, ratified by the County Assembly, Honourable Speaker, then it will be specific, Honourable Speaker, and it will be customized, Honourable Speaker, for the sake of the need of those particular persons, Honourable Speaker. Honourable Speaker, and I will not also tire, like just Honourable Millie Odhiambo, in talking about persons with disability, that they should be involved, because our Constitution, Article 54, especially 2A, Honourable Speaker, specifically talk about involvement of persons with disability in appointive and nominative position, Honourable Speaker, so that as we put in place all these instruments, Honourable Speaker, we also, the county assemblies, we also urge them, Honourable Speaker, to make sure that persons with disability are involved fully so that they cannot be marginalized since they have been marginalized for a long time. We don't want that marginalization to be devolved to county government and county assemblies, Honorable Speaker. So, Honorable Speaker, this is a very nice, that's a very important bill, and I do support, Honorable Speaker, and I urge my colleagues, members of Parliament, of this august House, to also support this bill so that we will have structures in our county government and county assemblies, Honorable Speaker, so that devolution can really work. Thank you very much, Honorable Speaker.
Member for Kabondo Kaspul. Member for Kabondo Kaspul, Honorable Ivo Barra. What has happened?
What has happened? Okay. Thank you very much, Mr. Speaker, and I too stand to support the bill. Mr. Speaker, the bill is important as it provides for a clear framework for handling statutory instruments from the beginning to the end. Mr. Speaker, the main issues, I'll pick two. The main issues, and the two that I have picked, are on the fundamental shift that this bill introduces, is that it provides for a regulatory impact assessment at the intended regulation, which is critical in determining why the regulation is necessary and its potential impact on the affected parties. Mr. Speaker, it also provides for a framework for county governments to apply its terms of scrutiny and operations in respect of statutory instruments. Once again, I support. Thank you.
Member for Nyaribari Chache.
Thank you, Honorable Speaker, for the opportunity also to support this bill, because I think it's going to make a difference in the way we manage our affairs at the county level, now that the country has decided to go devolution way. Honorable Speaker, if we can fix it and get it right at the county level, I'm sure the country will be a better place to live in. Like one of the great servants of this world said, Mother Teresa, if I quote her, she said that if all of us can clean the front of our houses, the entire country or world will be a better place to live in. If our counties can get it right, Honorable Speaker, and all of them do their best in terms of giving services to the public, then the country will be a very good place to live in. Then we'll have eliminated the complaints we have from people that the national government has not done this. The blame game would be a thing of the past. Honorable Speaker, I would only urge that when that is going to happen, one of the ways to domesticate, to operationalize this bill, would be by way of public participation. If there's an appeal, if there's a law they're going to pass, they should involve the public. And one way of involving the public, Honorable Speaker, is to doing the notice, informing the public of what's pending, and if possible, do it in the mother tongue, Honorable Speaker. I was listening to Honorable Midi Odhiambo, and I'm quite concerned about the boy child. Yesterday, Honorable Speaker, had an opportunity of presenting a pass to one of my local secondary school, Amariva Secondary School to be precise. And when we were assessing the number of students enrolled in the school, more than 60% are girls. About 40% are only boys. And that begs the question, where are the boys? What are we doing to empower them also? When these girls are of age of getting married, for example, where are the boys who are going to marry them? Because if we don't prepare them now, they'll be afraid of them, Honorable Speaker. Just the same way this bill is attempting to address the inequalities we have at the county level, I'm sure we'll be able to do a lot more. Even as they come up with the laws which are going to govern the counties, they must look at the bigger picture, Honorable Speaker, because some counties are too small to have too restrictive laws, because we trade across the counties. I would encourage a situation where we have amalgamated the counties, where all of them are going to sit down and agree on the laws which are going to govern all of them, so that they don't hurt or shoot themselves in the foot by way of making the laws which are going to limit them on how to trade, how to partner with the neighboring counties, Honorable Speaker. Kisii, for example, is known for banana, among other fruits. Kisii is known for avocado, which grows effortlessly. If we don't develop the laws which are going to enable us to sell those products, Honorable Speaker, then we'll have hurt our people without planning to do it. So even as we support this bill, Honorable Speaker, I think we also need to encourage the counties to do it and do it well. I would be happy at some point if we could get to a point where we are going to have a model like what we have in CDF, that by the time the money is leaving Treasury going to the counties, we all know what that money is going to do. Even if it's not 100%, if 50% of the development project will be able to know what it's going to do, then the public will be empowered to know how their money has been spent. As it is, Honorable Speaker, it's up the whims of the governor and his leadership to decide on how much to put on development. It's up to them to decide on where that money should go. You get a county which has 9 constituencies, for example, in Kisii. The governor can decide to take money to one side of the county, and then that leaves the rest of the counties, the constituencies suffering, Honorable Speaker. If these laws can be made in such a way that the counties or the constituencies are all involved, and projects are decided ahead of time before even they receive the money, Honorable Speaker, I think that would be one major step of addressing the misuse of the monies we have at the county level, and hence curtailing the corruption that is being said to be at the county level, Honorable Speaker. Because we cannot keep on whining and saying that things are not working at the counties, and yet we are not doing anything about it. I'm grateful that PPI is attempting, Honorable Speaker, to address the issues of the management of the ward level. The 5% money which will be allocated to the ward level will in somewhat try to attempt to bring equity in matters development. But 5%, Honorable Speaker, of say 100 million, divided by the number of wards, if you have 20 wards or 40 wards, that's only 2 million, Honorable Speaker. It is not enough compared with the kind of money that goes to the county. It's a good start, but certainly not enough to address the challenges that we have at the county level, Honorable Speaker. So we must deliberately go out of our way and make sure that we have a way of ensuring that projects are known, that by opening the computer, all of us can tell the projects which are being undertaken in Meru. By just a click of the button, we'll tell the projects that's being undertaken by the Nairobi County government. That way we'll be able to address the issues that we're having today. Today, if somebody wants to know the project my CDF is doing in the constituency, they don't need to see me. All they need to do is to go to the website of CDF, and they will see all the projects that CDF is doing. And that gives us somehow a way of assessing ourselves and trying to be balanced by way of dividing the money that we have at our custody. With those many remarks, Honorable Speaker, I support this bill. I think it's going to help us as a country, but I would wish we have some of those issues of budgeting incorporated so that we have a way of measuring that which goes to the county. Like the management, they say, Honorable Speaker, that if we can't measure. If it cannot be measured, it should not be rewarded. So if we cannot measure it, then we have no capacity or we have no tools to measure that which they have achieved. I support. Thank you.
Member for Kitui Central.
Yeah, thank you very much, Honorable Speaker, for giving me the opportunity also to add my voice into this important bill. the County Statutory Instruments Bill, Senate Bill 2018. Honorable Speaker, when you look at this bill, it is a bill of 2018, and today is 2021, which means it has been doing the rounds for about 3 years. And that's why really I don't agree with those who are saying it's a timely bill. I think, Honorable Speaker, this bill should have been passed a long time ago. And basically it's because you look at the design of the county assemblies and the parliament, Honorable Speaker. The National Assembly is supposed to be like a replica of the county assemblies, so that what we do here is also being down on the ground there. But the good thing, Honorable Speaker, is that we have now the bill with us as a National Assembly. And that's why I want to thank the House Business for allocating time for this important bill. The whole issue of delegated legislation, Honorable Speaker, is something which really as a House has benefited the country. Why am I saying so? Basically because, Honorable Speaker, cabinet secretaries and the CECs at the county level, to some extent, have now a window where they can also participate in legislation. And what is critical is through this bill, the county assemblies now will have a way to ensure that that delegated authority is not abused and is used for the benefit of the counties, Honorable Speaker. The whole issue of regulations, Honorable Speaker, is to provide what we call an operational framework, so that when a law is passed, the nitty-gritty details of how to operationalize that law might not be captured at the main law. And what happens is now in the regulations, you're able to capture much more details, Honorable Speaker. And as a result of that, then you realize that in terms of implementing, there's a clear structure of how to implement some of the issues which have been agreed on through the law, Honorable Speaker. Honorable Speaker, I think the challenge which we have been facing both at the national level and the county level is the issue of public participation. And that's the issue Honorable Millie and Honorable 001 were mentioning. To me, I think, Honorable Speaker, if we get it corrected at times of public participation, then there will be inclusion, and everybody will feel like a sense of belonging in terms of giving their input. But, Honorable Speaker, we all know there has also been a number of bills which are targeting public participation from the Senate, but they are still doing their rounds, and we have not been able to finalize them. And I think, Honorable Speaker, the time we pass a law which focuses on public participation, so that we have a clearly good framework on how to conduct public participation, then the women, people living with disabilities, the elderly, and all those other marginalized groups, Honorable Speaker, will have a sense of belonging, a sense of inclusion, and a sense of participation. And to me, I think that is what is critical. The other area, Honorable Speaker, is the area where county governments are unique in their own sense. For example, if you pick the county government of Kitui and pick another one like the county government of Mandera, they have unique needs. And I think the county assemblies are expected to provide legal frameworks which will assist these particular county governments to address the needs of their people. Honorable Speaker, one of the cross-cutting issues is issues to do with own revenue generation, where every county in this country is collecting money other than the money going from the national government, the so-called equitable share. You go to each county, they are collecting money. And one of the challenges we are facing, Honorable Speaker, is that despite these counties collecting money, the structure on how to use the money, once you collect the money, the structure on in terms of how do you collect it and how do you use it, there are lots of gaps. And you find that, Honorable Speaker, these days, most county governments are collecting much lower amounts when you compare them to what the so-called local governments, the de facto local governments. And you ask yourself, how come now that the county governments are not able to collect much more as compared to the local governments? And basically because the expected regulations to determine how to go about it, some have not been done approved by the county assemblies. And to me, I see this proposed bill, once first to become an act of parliament, going a long way in providing that framework to ensure that things are done correctly. The other point, Honorable Speaker, is that most county governments are also investing. They have actually investments. I have in mind, you go to a place like Kitui County, we have what we call Kikotech. You go there, you find they're also now starting some pharmacy production plants. And what is happening, Honorable Speaker, is where a county is investing, then it will also be important to have regulations which determine or which guide the whole process of investment so that they get value for money. What I would call, they get good returns for their investment. So to me, when I see this law, Honorable Speaker, because it's delegated legislation, I see an opportunity where CECs in charge of trade, CECs in charge of finance, should be able to forward to their county assemblies regulations which now will provide that required legal framework to make sure that things are done in the right way. As I conclude, at this level, Honorable Speaker, the National Assembly level, we only get to interact as a House with those regulations when they have been proposed for annulment. And so many of them go through just the committee and they die there, and if you have interest, you could go and pick them to read, but they never get to the House. And I think to me, because county assemblies are many, they are not like just the National Assembly, which is one, I would encourage a situation where even those regulations which have been approved by the committee in charge of delegated authority are also being taken through the House, so that the membership of the House can get to know what is being proposed in the regulations. And they can easily align the proposals with the main act which has been passed by the Assembly. So with those many remarks, Honorable Speaker, I just wish that as a House, I want to appeal to all the colleagues that we fast track this Senate bill so that we pass it and it becomes an act of parliament so that the county assemblies can engage in a serious review of all the delegated, the regulations which have been prepared by different county assemblies. And that will assist this country even as we assist the county governments. With those many remarks, I support, Honorable Speaker. Thank you very much.
Member for Saku.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to add my voice to the contribution on this particular bill. I'm attracted to the object of this particular bill, which is to provide a comprehensive framework for the making, scrutiny, publication, and operation of statutory instruments. Honorable Speaker, when we had the counties in 2013, the counties were actually taken through all the systems of the National Assembly. And I think the National Assembly, under your leadership, provided a lot of guidance. They lacked the human resource capacity, the legal, the legislative, and also the grasp of the constitutional issues to be able to even make laws at that level. Mr. Speaker, through this particular bill, that if this House passes, will become an act of parliament, then we see that the different county assemblies will be able to make their own local laws. But what we must really guide and look after as this House is two neighboring counties. Let us say they are coffee counties, tea counties. they should not come up with different statutory instruments that maybe are in contradiction, that imposes levies or taxation that is likely to hurt. Those of us who travel long distances, you will find in many places toll stations, or what you call the taxation roadblocks between Meru and Isiolo, between Isiolo and Marsabit, between Nanyuki, Laikipia, and Meru, and all that. So through this, I think we will be able to have certain standardized system that will be operating at that devolved local level. Mr. Speaker, my colleagues have talked about public participation. Clause 8 talks about publication in the Kenya Gazette, one paper of wide national coverage. If we look at our rural people, many of them, you must talk to them through meetings, barazas, town halls, for this particular law that will affect them. So in terms of public participation, I think the different counties, or counties must go out of their way to be able to reach the public in a different way than that is being undertaken by the National Assembly. Finally, Honorable Speaker, through this particular bill, I think they have also provided adequate guidance in terms of the no-go areas that the county assemblies should not undertake, or if they do undertake, they must be very clear that it does not contradict the Constitution. That is the law of the land, such that the County Assembly of Mandera and the County Assembly of Kisumu should actually have a regulation that is within the law. With those few remarks, Mr. Speaker, I beg to support.
Member for Bodo.
Thank you, Mr. Speaker. Mr. Speaker, once again, we don't want to doubt the position of the whole issue of statutory instruments. We've seen them, they're important. We have applied them nationally, and we have used them over a period of time. Now, having them in the counties is as critical as having them in the national government. But the biggest problem, Mr. Speaker, and this one, maybe you may go down in history, Mr. Speaker, that this parliament does not bequeath to the next parliament the kind of see what we are doing at the moment, what the Senate is doing and what the National Assembly is doing, the amount of burden that we have, how I would have wished that we don't bequeath the next parliament with this kind of a burden. Because as at the moment, assuming in terms of procedure and application, assuming that Nakuru County government by last year had developed their own statutory instruments based in the understanding of what happened as the national statutory instruments, what will this law mean to them by now as a law that's generated by the Senate? So, Mr. Speaker, I'm seeing a situation where we are deliberately doing legislations and we are very clear, if not so much clear, that we are doing them in vain. Who is to implement this legislation? Because in my view, a county assembly, a specific county assembly specific to a particular county, is supposed to come up with their legislation. And once they come up with their legislation, under a little guide from the national legislation that exists, then it is that legislation that they are able to implement. So how are we, or how is a county government able to implement this legislation the way it is, unless it remains a reference material? And it remains as a reference material as at that. Because definitely each county assembly is supposed to come up with their legislations. And in the way the laws are done, in the way the Constitution is arranged, there's nowhere where we are seeing that a county government, a specific county government, is supposed to be implementing some legislations from the Senate. So Mr. Speaker, I'm seeing a big problem in terms of how we are moving forward. I don't doubt the importance of the law. I don't doubt the importance of having these statutory instruments. But the main problem is the whole issue of implementability, the whole issue of Parliament working in vain, the whole issue of where do we reposite this as a legislation. Because it's going to be running parallel to what exists in the name of the National Statutory Instruments Act, which we know, and then now there's also another new one now from the Senate. Now, the one that is from the Senate is very clearly not going to be implemented by any, because Senate has no mechanism of even following it up whether it is implemented or not. So, Mr. Speaker, in my view, and I want to repeat this, Mr. Speaker, that this Parliament, in my view, we need to come up with some way of lessening the burden of double legislation, of lessening the burden of doing legislations in vain. Because if we don't do it, I think we are going to have a big problem in the next Parliament, which is going to be bigger, a bigger Senate, a bigger National Assembly, and with the burden that is inherited from what we are not able to correct, Mr. Speaker. How I wish that at this moment, even through our CIOC, we were able to try to look at some of these things so that we get to see how do we harmonize some of these processes. If the Constitution does not provide them in a very clear manner, can we procedurally in the House, can we procedurally between the Senate and the National Assembly get a way or how we can harness some of this so that we don't continue with this burden that we are in at the moment? Thank you, Mr. Speaker.
Serious points, Honorable Ochanda. Of course, when you raised that issue, what came to my mind was the provisions of Article 96, Clause 3, about the oversight authority that is bestowed on the Senate. That oversight authority is only with regard to revenue, finances, not about what laws are, how laws are implemented by the county assemblies. I don't know, maybe let me hear from a member of the Committee of Experts, defunct, Honorable Tiende Molo.
Thank you, Mr. Speaker. Mr. Speaker, from the outset, I support this bill. Mr. Speaker, in my view, this is one of those rare instances when the Senate has properly exercised its jurisdiction on matters relevant to it. There are many instances when, in my view, the Senate has been overreaching on matters that do not concern county government. Mr. Speaker, I say that it is a proper one because the primary purpose of the Senate is to protect the interests of the counties. And that includes not just the interest of the people of the county or the interest of the governor, it also includes the interests of the representatives of the people there. And what this bill then seeks to do is to put in a very clear and timely manner how statutory instruments are to be enacted within the county and the limitation of the governor and his or her CECs. Mr. Speaker, it becomes a very good counterpart to an already existing legislation, the Statutory Instruments Act of 2013. But the Statutory Instrument Act of 2013, on its face and on a clear reading, seemed to have concentrated on national legislation and not so much on the county level legislation. And that is why I think it is quite important. Mr. Speaker, this bill at Section 5 helps us in a very fundamental way, at least at the county level, in terms of this animal called public participation. Mr. Speaker, you know that to date, that idea of public participation has been a thorn in the flesh even of this House. And it has become the discretion of every judge to discuss, to decide whether there was sufficient public participation or not. It has become what we'd call the length of the chancellor's foot. What this bill does, at least at the county level, it prescribes in detail the manner and mode of public participation in a way that lends itself not to defeat an instrument after it is enacted. In ours, we are still at the mercy of interpretation. Mr. Speaker, the proposed Section 6 then does something that is very innovative, what it calls the regulatory impact assessment, along the lines of the environmental impact assessment. And this is quite important because it gives both the county and the people of that county an opportunity to re-examine that instrument, its cost, whether there's an alternative, and its effects. And that, I think, is very important. It is something that even at the national level, we have not always done sufficiently. Mr. Speaker, lastly, in support of this bill empowers the county assembly. It empowers the county assembly because it removes the whims of the governor in terms of making decrees that then have the force of law at the county level. Because every instrument then must be brought to the county assembly within 7 days. And it must be passed by the county assembly. And if it is either not brought within the prescribed time or not passed, then it cannot have the force of law. It binds the governor and his or her government to ensure accountability by presenting all those things that they want to have the force of law before the county government. And I think that is very important. I only have one problem with it. That is the proposed Section 18. Section 18 does something that I have never seen in any legislation. It stipulates that whatever instrument is passed, it will cease to have effect exactly 10 years from the date that it was passed. I have never seen any legislation that contemplates its own death without any invitation. It is very curious, Mr. Speaker, because legislation and statutory instruments are supposed to exist in perpetuity until and unless the body that enacted them chooses to repeal them or to amend them. A proposal that you can make a statutory instrument after all these proposals and then it automatically lapses, for me, flies in the face of all constitutional propositions that I know. And it also flies in the case of logic. And what's more curious is that then it proposes that the only thing that can save that automatic death is if the regulations say that it does not have to die. Mr. Speaker, it is strike law that regulations cannot be enacted to contradict a substantive provision in the Act, which means there is no way any regulation can save any instrument if this particular part passes. That is my only issue with it, Mr. Speaker, which I believe that our committee and this august House will give due consideration during the committee of the House and necessary amendments. But with that, Mr. Speaker, I support.
Obviously, I would imagine that any regulation at the county level would have to be based on some existing legislation, substantive legislation. And therefore, it's illogical to imagine that the subsidiary legislation could subsist in the face of a deleted, if the law is itself deleted. I suspect the Honorable Otiende, that's the point you have. Anyway, member for Kaliani.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, I stand to support this county statutory instruments bill. This basically, Mr. Speaker, deals with the delegated legislation. And these are the laws that are given to, the powers given to regulation-making authorities so that they can be able to actualize laws that are already passed by the assemblies. Mr. Speaker, I hope that when this goes to the counties, that our governors will be respectful of these laws, because I've seen many times where the legislation in the county assemblies is completely ignored and rubbished by governors. A case in point is our county assembly of Machakos, where the CECs during vetting were actually rejected by the MCAs, and they still have been in office since that time. It's unfortunate. So I'm just wishing that when we pass this, it doesn't go and get abused by the leadership in the counties. They must begin to believe in the rule of law. Mr. Speaker, a lot of this has been picked from the Statutory Instruments Act, which basically is used by the delegated legislation of this House, and also for regulatory making authorities at the national level. But in my observation of that act, I've seen certain flaws. Maybe not completely negative, but certain things that they've picked which I think they needed to have thought through. The first one, Mr. Speaker, is in the definition of a statutory instrument. Mr. Speaker, the definition is extremely wide because it talks about any rule, any order, any regulation, any direction, any form, any tariff of costs or fees, any letters, patent, commission, warrant, proclamation, resolution, guideline, all those. And Mr. Speaker, those are so wide such that anything a CEC or a governor does from their office suddenly becomes or seems to be a regulation. And that's one of the problems we've been having even at the national level. Because there's so many things that ministers will do, and we are not too sure how exactly to handle them because they pass proclamations, they pass guidelines in their offices, and they say that's not one of the things that should come to the House. A case in point, Mr. Speaker, was when the Treasury made a decision that you cannot be able to deposit or withdraw more than a certain amount of money. That was a guideline. Unfortunately, it didn't come to the House as a regulation. Yet clearly it has a force of law and impacts on a lot of people and how they do business. So, Mr. Speaker, I think the wide definition, they needed to have considered to reduce it so that it's very specific to the things that are going to affect county business. Mr. Speaker, the other issue, which has been canvassed by my colleagues, is the issue of public participation, the threshold. This is one of the problems that we have constantly faced because when it comes to public participation, the question is who must be consulted? And many times you find it seems like everybody must be consulted. Even when we put it out to the public, even if people do not respond to the adverts, there's always that argument that this so-and-so or such a sector is affected. And so they should have been given an opportunity. So this definition needs to be clear. Exactly who should participate in order to be consulted in consideration before making a statutory instrument. Mr. Speaker, another issue I've noted is a lot of times the regulatory making authorities would avoid the regulatory impact statement because that is a statement that confirms to the public the amount, whether it is going to be expensive for the public, what it will cost the public, and many times they want to avoid that. In fact, a lot of statutory instruments brought to this House do not even have the regulatory impact assessment because they always try to wiggle out of it. So, Mr. Speaker, this is important, and I think it's important that the county assemblies follow through. Finally, Mr. Speaker, is the issue of when scrutinizing a statutory instrument by a county assembly, there needs to be that pre-publication scrutiny. I would advise county assemblies, when this law passes, that they ensure that before any regulation is published, they go through a pre-publication scrutiny. Because we have noted that a lot of times regulatory making authorities would go ahead and publish in the Kenya Gazette, and that is the time at which we come face to face with the regulations. And many times there are some very basic flaws or different, just minor things that need to be changed. Unfortunately, once it is published, then the only recourse that we have, which is also in this law for the county assemblies, is that they have to annul. So it becomes an exercise in futility when regulatory making authorities make a regulation, publish it, send it to the assembly, and then it is rejected. So it is important that they ensure that there is a pre-publication scrutiny where both parties, the county assemblies and the regulatory making authorities, that would be the CECs and the governor's team, make meetings and discuss so that by the time this thing is published, it becomes law without wastage of much time. With those remarks, Mr. Speaker, I thank you and I support.
This issue of public participation, and because I know there are some, I think 2 or 3 bills, it's also important that even as a House, we look at it with a lot of care. Because parliaments the world over regulate their own procedures. To have an act of parliament decreeing what amounts to public participation, sufficient or insufficient, for me, I think it flies in the face of the independent role that parliaments the world over have in regulating their own procedures. It's a good thing that we know it is there in our constitution, but I think also we might, these are things that must be found in the rules of houses of parliament. You cannot go to make a law, a standalone act of parliament, to come and regulate or state what is public participation. Otherwise, because, you know, to even change anything in that law, you need to amend it, to repeal it. But you know, with the reason why those things are best left to the procedures of the houses, because the houses do regulate their own procedures. But of course, again, and I like what the Honorable Tina Molos talked about, the interpretation. Because even as we sit, notwithstanding the directions we gave last week regarding the documents that were brought from some ministry on economic partnership agreement, notwithstanding that we instructed that there be fresh public hearings, some other tired bodies have rushed to court to say that they need now the courts to decree that there must be sufficient. So, you know, now, so you see the danger of having some of these things put in legislation, that you want sufficient public participation, surely. Once in many jurisdictions that I know of, parliaments merely advertise. In fact, these days of technology, you just put it in your website. Those who care to follow and understand what parliaments are doing will pay interest or pay attention. In fact, in many jurisdictions, people you are told, you want to address us on which area of this legislation. How much time do you require? If you are a person who has researched, if you have researched well, would you want 1 hour, 30 minutes? You know, things like those. So that it is something that is going to inform the House or enrich that which is going to be the product from the House or from that process. But, you know, public participation cannot be, you go and hold a baraza and then and people are just asking for chai and other things, and mandazi. That you cannot call us to come to this hall and fail to give us transport back to we came. Now that you call it public participation, surely. We must also look at some of these things so that even as committees of this House, when we go out there, if you find that the people coming, they are just coming because they have been told that some visitors who are here, and the Waheshimiwa are here. I mean, you are the liberty to call it off and say you want something more impactful. Member for Homa Bay.
Thank you, Mr. Speaker. Mr. Speaker, I came for the evening session to deal with the matter of narcotic drugs. And I have to be honest, I have not looked at this law, but I've listened to various presentations here. More so from Honorable Chanda, Honorable Tiendia Molo, Honorable Makali, and Bui. And Mr. Speaker, it is now, if the matters they are speaking to are the matters in that proposed legislation from the Senate, then I'm worried we are wasting our time on something which should not be discussed by a House of Parliament up here. Mr. Speaker, I'm giving 4 reasons as to why this bill is for rejection. And I'm saying it is outright ex facie unconstitutional. Mr. Speaker, a look at our Constitution. 48 governments are established in Kenya. 1 national government and a government in each of the 47 counties. That is the language of the Constitution. The Constitution says they will be distinct but interdependent. At the national level, we have the parliament with these 2 houses as the legislative arm of the national government. At the counties, we have county assemblies as the legislative arm of those governments. What is not shared to the government down there is the judiciary. Mr. Speaker, therefore, the question we must ask, how does the parliament of the national government, which both the Senate and the National Assembly are, how do they sit to begin prescribing for the parliaments in the counties how matters to deal with subsidiary legislation will be dealt with. There are 47 of them. Remember, members, subsidiary legislations or regulations are out of delegated authority. And as the speaker has rightly said, that authority will be delegated by that parliament, which is the county assembly in the context of counties, through a legislation of the county down there. It is that legislation in the county that will say, in this circumstance, there could be delegated legislation or regulations of this nature. And it is that legislation in that individual county down there that will prescribe matters around which regulations can be made. It cannot be for this House, therefore, to come up with a law which is going to tie the hand or dictate to the assemblies down there, our co-equivalent at the county level, how they want to do their things, and what regulations can be made. And on that account, Mr. Speaker, I'm saying we must reject because it is unconstitutional. It is the national government through the parliament dictating now to the county governments and the assemblies how regulated authorities will be spoken about. Mr. Speaker, you've spoken to public participation, and I'm happy. Mr. Speaker, it is like you are seeing my thought. You know, parliaments all over the world undertake and transact their businesses under their internal procedures. And those internal procedures are in the form of standing orders. Those standing orders have their anchorage under the Constitution, in our case. And so we are told, you will regulate your procedures, you will provide in the standing orders how you do things. What if, in the manner proposed in the various legislations, Mr. Speaker, you referred to, and you are waiting to contribute on them to have them killed? What if, as has been happening now, you go for public participation somewhere, and people are asking you for fare? And this is something all committee members are seeing when we go outside there. They want fare, we did not drink water, there was no food, and then what is the value? The people gathered in a room during those public participation forums, what is the value that they are bringing to the legislative or the public issue you are investigating down there? And that is why you are right, Mr. Speaker, that if we are to come with a law in terms of public participation in legislation, it must find its space within the standing orders so we can prescribe it. Not some single law, honorable members, where it dictates. Remember, this legislative process goes beyond the House. You have a public participation law, it will go to the executive for assent. What if it is sent back here with provisions which end up tying your hands completely in terms of your legislation? What will you do? Let us go to our standing orders, because that is what the Constitution says. Honorable Speaker, Honorable Tienda Molo has said, some governors can run amok and be issuing decrees which are unlawful. But that is the work of the members of the county assembly down there. Number one, to check whether these decrees have anchorage in some parent law issued by that assembly. If not, whether the governor is therefore misconducting himself, in which case they have the power to initiate their impeachment down there on account of gross abuse of the law. So we should not take worries which are down there and imagine, as Parliament of the Republic of Kenya, we want to have some legislative oversight over parliaments in the counties. The parliament in Homa Bay wants to prescribe by their law how fishing matters are dealt with and how regulations around that are treated outside of the confines of what the parliament in Murang'a, the parliament in Kiambu wants to do their business. And that is why they are distinct. That is the word of the Constitution. So, Mr. Speaker, I urge that this particular one is really, to be killed. This is the kind of a matter, Mr. Speaker, where I agree with the courts. If you were consulted earlier on the constitutionality of this bill before it was transacted by our sister house, Mr. Speaker, knowing your brain, this is not something that would have taken our legislative time when we have such serious matters waiting. I urge the members to take the position that the views Honorable Amolo is giving us and others cannot save this thing. It is for rejection. Now that there is no ruling finding it unconstitutional. I thank you, Mr. Speaker.
Honorable Kaluma thinks that there is a legislative overreach. Is this? Honorable Wangwe.
Thank you, Honorable Speaker. Honorable Speaker, I rise on a point of order, especially following the legal opinion or mind that Honorable Kaluma has spoken. Honorable Speaker, for the benefit of those of us who are not lawyers, will I be in order, Honorable Speaker, to seek that you make a ruling instead of putting it to a vote? Because this calls for a vote, Honorable Speaker, might allow this House to vote over an illegality, should the motion be in a manner in which Honorable Kaluma has said. And Honorable Speaker, on that point, that is to why I say, I am asking, will I be in order to seek that you give a ruling as in whether this House is debating a properly constitutional bill before the House, Honorable Speaker. Thank you, Honorable Speaker.
Now, Honorable Wangwe, let me not go into the constitutionality of the bill before the House at this point. But the issue you've raised is, it's of great moment. We will look into the constitutionality of the matter of the bill. But for the time being, I will allow those members who are interested, or the mover, or the members who still want to. Because I've just noticed that there's some members who are actually here for the other business. Yeah. The bill. What did you say, the member for Nyando?
I thank you, Honorable Speaker. Honorable Speaker, I duly acknowledge the contributions, valuable contributions by members of this House, and at the same time also take cognizance of the mood of the House. And therefore, I would seek your indulgence to invoke Standing Order number 95 to have the mover to reply. And I thank you. And that is the mood of the House.
The Honorable Jared Okello has certainly not. But maybe we could just test. The member for Nyando having a reason in his place and claimed that reading the mood in the House, that it is safe that the mover be called upon to reply. May I put the question that the mover be called upon to reply? Will as many as of that opinion say aye? Aye. And many of the contrary opinion say nay. The ayes have it. So the member for Nyando read the mood correctly. Honorable Kamket.
Thank you, Mr. Speaker. I beg to reply. I think the Honorable Member for Nyando actually has what was once referred to as the mood meter or moodometer to measure the mood of the House. Mr. Speaker, sir, I want to begin by appreciating the last speaker, the Honorable Kaluma, who passionately made a pitch for rejection of this bill. But, Mr. Speaker, I want to refer Honorable Kaluma to Article 108 of the Constitution. Is 108?
108 is on,
Not 108. Sorry,
ranking in the House.
Forgive me, Mr. Speaker. Forgive me, sir. Article, it's about conflict of laws. Article 191, actually, Article 191, sorry, Article 191 of the Constitution, which is Article 191, 2, talks about national legislation prevails over county legislation. Let me quote it. A, if the national legislation applies uniformly throughout Kenya and any of the conditions specified in Clause 3 is satisfied. Any of the conditions specified in Clause 3 is satisfied. The conditions, Mr. Speaker, in Clause 3, B, the national legislation provides for a matter that to be dealt with effectively requires uniformity across the nation. And the national legislation provides that uniformity is established provides that uniformity by establishing norms and standards or national policies. I believe, Mr. Speaker, if with that reading of the Constitution, in my view, Mr. Speaker, it may address the issues or the fears raised by the Honorable Kaluma in terms of the need for this legislation to provide for a regulatory framework for county assemblies to look at statutory instruments. Mr. Speaker, sir, I want to appreciate all the members who contributed to this bill. A majority of them, of course, except for that moved by Honorable Kaluma, who have actually supported this bill. I listened very carefully to the issues raised by members, and I believe that this law by Senate is basically to address is to bring a specific law to address the issue of statutory instruments in the county assemblies. I heard what Honorable Otiende Amolo raised about Section 18. Section 18. But Honorable Amolo, that section is also provided for, if you look at even the National Statutory Instruments Act 2013, has the same provision. And if you look at Section 20 of the Statutory Instruments Act, the National Statutory Instruments Act, that provision is also there. And it's a very good provision in law, Section 20. Let me read for you. It talks about staged automatic expiry of statutory instruments. And the purpose of this part is to reduce substantially the regulatory burden on the people of Kenya without compromising law and order and essential economic, environmental, and social objectives. I think that addresses and many other, if you go through it entirely, that it's also to ensure subordinate legislation is relevant to the economic, social, and the general well-being of the people of Kenya, ensure the part of Kenya statute books consisting of statutory instruments is of the highest standard. I think it's about to ensure that whatever statutory instruments that are brought to bear do not last forever, given the changing circumstances in the lives of the people. Mr. Speaker, sir, I have on the matter of the public participation, I have had the very interesting issues that are raised by yourself and the Honorable Kaluma. But let me put it this way, Mr. Speaker, and many other members who raised this matter, even my colleague Honorable Mbui, who is a member of the committee, that the issues that members have raised on this bill, I would like members to concretize the issues they want to, if they want to improve any sections of the bill. I would like to encourage honorable members to concretize their contributions in terms of amendments at the right time, so that we like even the issues raised by member Honorable Makali Mulu, the idea that statutory instruments only come to the floor of the House, many statutory instruments come to the floor of the House only when they're coming for annulment. I think it's a very good idea, but he needs to concretize that so that we do not just make contributions and then we leave it there. If we really believe in terms of improving that legislation, let them. I know the elephant in the room is the matter of mediation, that members sometimes do not want to get tied into the long process of mediation. And members want to get through with it and let this law pass. But if you strongly believe, as a member of this assembly, that a certain addition or subtraction needs to come in the bill, you're free to bring your issue in terms of amendments. But otherwise, Mr. Speaker, sir, I feel that the members really understood this bill. And in terms of helping the county assemblies, when this bill becomes law, it will help the county assemblies in doing their work in a smarter way. Mr. Speaker, speaking in retrospection as a former Speaker of a county assembly, you know, it's been quite chaotic down there, and it continues to be. So that now this House, this National Assembly, is the mirror of that should help the young assemblies that we are growing constitutionally. So that, Mr. Speaker, when we come up with such a very important law, in terms of helping the county assemblies to legislate properly and do their work in an orderly manner, I think, in my view, it's a positive step in terms of making things to flow in an orderly manner in the county assemblies. And I like to agree with members. The executive always has this idea of coming up with decrees and all manner of things without following the right procedure. And this Statutory Instruments Act, either at the county assembly or the National Assembly, it helps to put things in line. We have had to annul many regulations from this assembly. And I am sure in the county assemblies, there are very many pieces of legislation or decrees or whatever that have been made and have not followed. And these things have serious impact on the people. So with those few remarks, Mr. Speaker, I beg to reply. Thank you.
Very well. Of course, reasons for not proceeding to the next level, which was put in the question, glaring. So we move to the next order.
Order number 10, the Narcotics, Drugs and Psychotropic Substances Control Amendment Bill, National Assembly Bill number 27 of 2020, second reading.
Who's the mover? The chairperson, Departmental Committee, Honorable Koinange.
Thank you. Thank you, Honorable Speaker. Honorable Speaker, the main objective of the Narcotics, Drugs and Psychotropic Substances Control Amendment Bill 2020 is to amend the Narcotics, Drugs, Psychotropic Substances Control Act number 4 of 1994 in order to enhance penalties
related to the offenses in possession and trafficking in narcotics and psychotropic substances, define precursors and chemical substances which may be used in the manufacture of narcotics, define who law enforcement officers are in respect to the Act, prescribe offenses for a law enforcement officer who aids or abets or is accessory to any offense under the Act, provide for the offenses arising out of conspiracy, provide for power to intercept communication and the admissibility of intercepted communication, and provide for an obligation to disclose information that may aid to prevent commission of offenses arising under the Act and that may secure the arrest of perpetrators of the crime. Honorable Speaker, the Narcotics, Drugs, Psychotropic Substances Control Amendment Bill 2020 was read for the first time on 8th October 2020 and subsequently committed to the committee as pursuant to Standing Order 127 in bracket 1 and for report to the House. The committee considered the bill in its sitting held on 15th to 17th November 2020 and adopted its report on Monday, 30th November 2020. Madam Speaker, in accordance to Article 118 of the Constitution and Standing Order 127 in bracket 3, the committee sought views from the public by way of written memoranda, institutions that made representations to the committee on the bill include the following: State Department for Interior and Citizen Service, Directorate of Criminal Investigation, and National Intelligence Service. Madam Speaker, the committee observed the following with regard to the bill: that in order to enhance the objectives of the bill, it was necessary to insert new definitions in the bill. They include clandestine, laboratory, market value, and public officer. The import of the proposed amendment is to curb illicit drug operations which can be set up in private, commercial, and mobile property and which pose risk to human health and surrounding environment. Madam Speaker, the sentence with respect to cannabis should be reduced in order to reflect the current practice in our courts. The proposed amendment is to provide that where a person satisfies the court that the cannabis was intended for his own consumption, imprisonment should be not more than 5 years or a fine of not more than 100,000 shillings. Madam Speaker, there is need for a new section to provide for landlords and owners of buildings to conduct due diligence on their tenants and occupiers of their premises in order to avoid setting up of clandestine laboratories. Madam Speaker, as I conclude, the committee observed that drug trafficking operations pose risk to human health, society, and the surrounding environment. The perpetrators of such acts include law enforcement officers and public officers. Therefore, the committee proposed a new section to provide for disqualification of persons from being elected or appointed to a public office where such persons are convicted under the Act. Madam Speaker, in view of the above, the committee has proposed amendments to the bill in order to enhance the objectives of the bill. I therefore invite the members to take time and read the report of the committee. Madam Speaker, as individuals, members of this House, we are called upon to make good decisions today for the sake of our future generations. We need to safeguard the future of our children and generations to come. It is about time that we acted like the developed world does when it comes to dealing with drug lords. Be ruthless with them. Madam Speaker, we also need to act firmly on the enablers of the illegal business of drugs, of narcotics, drugs, and psychotropic substances. These include some unscrupulous government officers and law enforcement officers, those who think that can illicitly enrich themselves at the expense of our children. Madam Speaker, if we do not act now, the risking our children being converted into zombies by the drug lords as we watch helplessly. I thank you, Madam Speaker, and now wish to move and ask Honorable Kaluma to second. Thank you, Madam Speaker.
Very well. The Honorable Kaluma for seconding.
Thank you, Honorable Speaker, and thank you, my chair, for ably moving this important bill. Honorable Speaker, the matter of narcotic drugs has been an issue in our country and across the world for a long time. So much so that we even have United Nations conventions and conventions within our own continent dealing with the matter. We've had this law for a very long time, but Madam Speaker, our societies are still being destroyed. If you go to the coast and several other places, the frontier countries in the north, drugs is decimating our societies. In fact, if you remember the main reason as to why President Trump was elected then, they're saying he's going to build a wall between the United States and Mexico. Because drugs is destroying the societies, those people supported him. Madam Speaker, having analyzed the situation as the departmental committee in charge and looked at the law, we found up to 6 gaps, which are the gaps we are seeking to have this House seal so that we can have a full stop to this matter. Honorable members, number 1, we are looking at the punishment regime for trafficking. And Madam Speaker, if you look at the current law, option is being given about paying fine for traffickers or imprisonment for life. And it has therefore become very easy for more so big or bulk traffickers. People can have a whole ship of cocaine to come and say, pay 3 times the value or that amount and escape being jailed. We are in this bill proposing that life imprisonment shall be mandatory for a convicted trafficker, in addition to fine amounting to 3 times the value of the drugs is found with. Why are we saying so? It has meant, Madam Speaker, that the consumers are suffering more than the traffickers. The other distinction we are making in terms of that charge is that even if you are found with a drug under the current framework around punishment, Madam Speaker, whether you are holding it, whether you are just consuming, the punishment is one in the manner I've spoken to. And Madam Speaker, the courts therefore, and lawyers appearing here will confirm, there has been a problem across our courts. Because you have a boy, a street boy there, who was given mere cannabis to smoke. This street boy, Madam Speaker, he goes to court, and the hands of the court are so tied because it is 20 years or a minimum of 10 million. So what are we saying? For traffickers, we are saying life imprisonment is mandatory in addition to payment of fines. But for consumers, most of cannabis, we are saying the sentence will be reduced to a maximum of 5 years or to a fine not exceeding 100,000. And it is the practice within our courts already. So that we don't have situations where our courts are being forced to give sentences which are not prescribed in law, which is in itself unconstitutional. The second thing we are dealing with in terms of the gap after punishment to deter is aiders and abettors. And honorable members, if you've looked at the situation or the apprehension of all drug dealers in the country, mostly they are the vehicle of a police officer or a vehicle assigned to the police officer. Because that vehicle, GK vehicle assigned to a police officer, will not be easily stopped. In other cases, you get it as a vehicle of a state officer. You've heard of vehicles granted to ministers, granted to other state officers being caught conveying. What does that confirm? That there is a way in which law enforcement officers and public officers have been aiding and abetting trafficking in drugs. What are we therefore proposing, Madam Speaker? Point of order.
Honorable Kaluma, there is an intervention by the member of Naval Kolo, the Honorable Fakolo.
Thank you, Madam Speaker. Madam Speaker, I rise on the point of order to seek that maybe the great colleague from Homa Bay, if he is aware, he has referred most of the debate to the American, how he built the wall, and finally, Honorable Speaker, he touched on the issue of cannabis sativa as being part of the narcotics.
Is it a point of order or a point of information?
Yes, Madam Speaker, it's a point of order because I didn't want to inform him. He's a very informed fella, so that's why I didn't want to put it as an order. Whether he's right, Honorable Speaker, to put it to the House, Honorable Speaker, that part of the narcotics is cannabis sativa. Yet, Honorable Speaker, he is very much informed and aware that it's not only a drug, but it's also medicinal.
Order. Leader, you're just rightfully admitting that it's a point of information. And as a matter of procedure of this House, you should have inquired from the Honorable Kaluma whether he wants to be informed by you. But again, this is already in his moving and seconding. Honorable Kaluma is seconding. So the order number 10 is not yet an asset of the House. And so please, as much as you wanted to inform him, and I'm sure you'll get your chance to speak to it in a House of debate. I rule that we have Honorable Kaluma second.
Yes.
When I propose the question, now it will become an asset of the House, and now members will be able to debate.
Yes, I thank you.
Yes, Honorable Kaluma. Carry on.
Yes, so honorable members, the public officers and law enforcement officers have been using the vessels granted to them to serve public interest to convey drugs. Why? Because there is no offense of aiding and abetting in their circumstances under the current act. So we are creating an offense against those law enforcement officers and public officers who will aid in trafficking of drugs and prescribing punishment for it. In fact, the additional punishment we are prescribing in addition to those fines and custodial sentence is that you will not hold public office if you are convicted of using public facilities or vessels granted to you to serve to traffic drugs. Those are provisions within the Act. The third thing, Honorable Speaker, you saw the situation on the trial of the Akasha brothers. And mainly, our courts were defeated here because of the restriction of evidence that you may acquire by intercepting communication, which they were easily compelled to release there when it was intercepted. So we are creating provisions for limited and confined interception of communication under Article 24 of the Constitution. And we are being alive to the fact, Madam Speaker, that there is a right to privacy and right to communication. So if you look at the proposed new clause 80, subclause A, we are saying the information that can be intercepted is only by an officer of the level of a chief inspector. And he cannot intercept without applying to the court. Because it is going to be an infringement or a restriction on fundamental right to privacy, that application must be made to the High Court by that officer with the consent of the Director of Public Prosecutions. And we've also said that the information you are intercepting will be limited, Madam Speaker, to finding information relevant to trafficking or the offense, so that a person does not come into your phone checking how you speak with your spouse or deal with those other matters. We've created an offense for law enforcement officers to seek to intercept communication from courts which do not relate to the matter, or to release those information improperly. And it is a very hefty punishment. Madam Speaker, we've dealt with the issue of precursor chemicals at the 4th level. And these are chemicals which are used to manufacture these drugs in some clandestine laboratories, which we are also making provisions for. Now, these precursor chemicals are not yet provided for. And Madam Speaker, you can get people moving with things which, in terms of the definitions of what amounts to drugs and psychotropic substances, they do not fall there. But they are the chemicals which are then used to manufacture these things. We are bringing that range there so that it can be dealt with. Lastly, Madam Speaker, these amendments seek to align the Narcotic Drugs and Psychotropic Substances Act to the United Nations Convention on matters relating to drugs in terms of definitions of what amounts to the drugs. I don't know, Madam Speaker, whether I have time, but because the chair had moved ably, I wanted to request, Madam Speaker, that the bill, if you look at it, Madam Speaker.
You have 1 minute.
Yes, I thank you, Madam Speaker. This bill will be looked at together with the additional amendments in the report, and I urge the members to look at them and join the committee, Madam Speaker, in supporting and approving this innovative legislation so that we can deal with this societal malady conclusively and once and for all. I thank you, Madam Speaker, and I second.
Very well. Members, I propose a question, which is that the Narcotics, Drugs, and Psychotropic Substances, that is Control Amendment Bill, National Assembly Bill number 27 of 2020, be now read a second time. Let me give the first minutes to the Honorable Ras Sohali, member for SACO.
Thank you very much, Madam Speaker. Madam Speaker, I rise to support this particular bill. This bill is very important. But we need really to look at it alongside the statutes, alongside some of what are the existing regulations. What Honorable MP for Navakolo talked about cannabis. It is available out there in the market. It is available on the street. But in Kenya now, we have not legalized. The street name of cannabis sativa is banned. It has not been legalized. But in the Western countries, what has been happening is we are told it is a medicinal drug that can be prescribed by doctors and physicians. Then the other thing about this bill, I think, is about those who are the major traffickers, whether it is from the Caribbean, whether it is from...
Order. Honorable Ras Sohali, member for SACO. I wish to disrupt your contribution to the bill. This being a house of procedure and rules, and I do order that you will have a balance of 8 minutes when the debate resumes on the Narcotics, Drugs, and Psychotropic Substances Control Amendment Bill, National Assembly Bill number 27 of 2020. And for that matter, you'll have a priority in speaking. Honourable members, the time being 9 p.m., this House stands adjourned until the Thursday, 4th March. Thursday, 4th March, yes, at 10 a.m. So ordered. Of course, 2021.